This presentation explains where to find a Notice of Appeal form for the Environment, Resources and Development Court and how to complete the appeal form. Before you lodge a Notice of Appeal with the court, you should ask yourself a few questions. The ERD court caters for self-represented people. However, legal advice is always recommended before instituting proceedings in any court. When considering whether to seek the help of a solicitor, think about how complex you think the matter is. Are there any legal or technical issues? Do you know if you have an automatic right to appeal? If so, it will normally say that you do on the notice or decision you wish to appeal. If you are a neighbour or third party, you only have an automatic right to appeal for Category 3 developments. We will talk about this later in the presentation. Also consider the costs. Legal help can be expensive, and sometimes the court may require you to obtain expert reports, which also add to the cost. The Legal Services Commission and the Environmental Defender's Office are good places to start for looking for legal advice. And remember, you can always engage a solicitor further down the track, and you can withdraw your appeal at any time. Have you received a decision notification form from counsel? If not, you will need to contact the counsel to obtain one. A copy of the decision or notice must be attached to your notice of appeal. Development Assessment Panel meeting minutes are not usually considered a formal, appealable decision. When you have decided that you want to appeal, you can obtain a copy of the Notice of Appeal from the court's website or by contacting the court. The name you write here will be the name that appears on all court records. It may be a company or a person. Write in your residential address, including your postcode. Please provide your contact numbers. If a hearing is cancelled, the court may need to contact you at short notice, and it helps to have more numbers to try. If you have an email address, the court can send you correspondence, including final judgments, by email. The address you write here will be the address where you will receive all court notices, as well as correspondence from the other side. This is a postal address and can be a PO box number or document exchange address. If this is the same as the residential address you have already written, please write as above. You may be appealing against a planning decision, for example, the council's decision to refuse you planning approval, or you may be appealing against a condition of the consent. If you are a representative, you may be appealing against the consent of someone else's development application. You may also be appealing an enforcement notice, for example, a Section 84 notice issued to you from your council. If all you have is the council's Development Assessment Panel meeting minutes, you should wait until you receive a formal decision notification form before lodging an appeal. You should find the date of decision written on your decision notification form. If you are appealing an enforcement notice, it may be the date of the letter you received from counsel. You may receive the decision a number of days after the date of the decision. Here you should write the date that you actually received notification of the decision or notice. The appeal period will run from this date in most circumstances. Try to remember the exact date, but if you do not, you can just write the month and year. The authority is normally your council, or it may be the Development Assessment Commission. You need to write the name of your council and their address here. You also need to send them a copy of your Notice of Appeal when it has been lodged with the court. What is the development for? It may be written on the decision notification form as nature of development. All development applications are given a category number of 1, 2, or 3. This relates to the level of public notification required. If you don't know the category number, you can contact the council to find out. If you are appealing against an enforcement notice, this probably won't apply. Here the applicant is the person or company that applied for development approval. It should be written on your decision notification form as applicant. The court checks to see if the name of the appellant is the same as the applicant here. If not, we may need to know your relationship to the applicant. For example, you may be appealing on behalf of the owner of the property, or your builder, planner, or architect may have lodged the original development application with your council. If you are a representative in a Category 3 application appealing against a consent, you just need to indicate that you are a representative in the next question. Is your appeal in relation to your application or someone else's? If you made written representation and were involved with the council's assessment of the development, you are a representative. Representatives have automatic right to appeal in Category 3 applications. This section is where you state the reasons why you are making the appeal. You should list your reasons in numbered paragraphs, and if you need more space, attach a separate sheet and write "See attached." You do not need to attach plans or reports at this stage, but you do need to attach a copy of the decision or notice that you are appealing. Is there good reason why the court should hear your appeal as a matter of urgency? Normally the court lists matters for compulsory conference 3 to 4 weeks after an appeal is lodged. If you think you need something more urgently than that, state your reasons why here. Your attendance at the day and time specified by the court is essential. You are expected to do everything you can to make it to your conference. If there are days that you know you will not be able to attend court for good reason, you can also state them here. For example, if you are travelling overseas. The appeal process is in 2 stages. The first is the conference stage, where parties are encouraged to reach a settlement or compromise. The second is a more formal court hearing or trial, where witnesses may be called and documents tendered as evidence, and the court makes a formal judgment. You may request to have the hearing by written submission only and a view of the subject land. At the conclusion of your hearing, the court normally will reserve the decision so that all of the evidence can be examined. When the judgment is published, you will receive a copy. Indicate here how you would prefer to receive your copy of the judgment. Once you have completed the Notice of Appeal form, check that all the details are correct and then sign and date the form. When it is lodged with the court and the filing fee is paid, it is your responsibility to send a copy of the appeal to the relevant council or authority. You can do this by post or by attending in person at council chambers. Once your appeal is lodged, your matter will be allocated an action number. You should receive notification of the date and time for your compulsory conference within a week by the letter sent to the address for service as nominated on your form. If you have any questions, you can contact the court Monday to Friday, 9 a.m. to 5 p.m. by phone, fax, or email. Alternatively, the court's website has lots of useful information. Follow the link from the court's homepage to the Environment, Resources and Development Court.